Eye on Politics. Your eyes should be on this station right now because we need you to understand what happened at The Hague last week. We need you to understand what Rule 68 means. We need you to understand what we should expect in the near future. So in case you're not on this channel or if you're on this channel, tell a friend to watch this channel and watch this program because this is a conversation every Kenyan should understand so that you're able to make informed political decisions and have informed political conversations. And isn't that what Eye on Politics is all about? Samuel Njoroge is my name. Remember to hit me up on Facebook. Samuel Njoroge is my username. Twitter too, at Sammy1Njoroge. And yes, I give my ring a break. I saw that comment on Facebook. I give it a break officially. And introduce Danstan Omari to my extreme left.
Thanks a lot, Sammy, and I feel honored to be in this prestigious talk show.
Welcome to the program. Asante sana. Joseph Simekha.
Good morning.
Karibu sana.
Asante sana.
The Kikoi is back. And we're loving the swag. Karibuni sana. Very quickly, because I know we've got around 29 minutes to do this. I'll start with you, Joseph, in terms of what happened at The Hague. Was it a win? Was it a lose? Was that a win-win situation for Kenya?
Well, it depends on, well, actually you've said for Kenya, it depends on the parties who is it that are considering themselves losers and who is it is that are considering themselves winners. If you define Kenya in terms of certain individuals, which is what often happens, and if what is being said is true, then Kenya won. But is that Kenya? You know, those individuals who define themselves as Kenya. Because this very same Kenya also has people called victims of post-electoral violence. Did those victims win? You have to ask those questions before you make any blanket statements in terms of whether there was a winner or a loser.
A winner,
Yeah, I have, as you've heard me, I think on this show, I argue very vehemently that I am very uncomfortable when it comes to people reducing these issues to individual cases and forgetting the broader concept and principle of law and the way it should serve humanity. And for us, it would be the entire humanity of this country called Kenya. Whatever position was arrived at, does it serve the entire humanity called Kenya? It isn't clear yet to me because I'm hearing two arguments. I was a bit consumed over the last 4 days in Zanzibar with the East Africa Law Society annual conference. And I'm hearing different positions, which I just, from now, want to follow up closely and find out what is the exact position.
Yes.
But if indeed the court, not the court, I'm sorry.
The ASP,
the ASP
Assembly of State
yes,
Parties.
I'm sorry. Thank you for that. If indeed it confirmed and affirmed, and that will be the official position, that there's no retroactive application of this particular rule to this certain specific cases, I would always argue that does it serve the cause of justice? For me, at the end of the day, that's going to be my argument, because I'm neither for nor against individually William Ruto and Sang. I sympathize with them. But the way we approach is, does it serve the cause of justice?
Cause of justice in this country.
In this country.
And of course, putting in mind what happened in 07, 08.
Yes.
But Omari,
Yes.
let's get to understand exactly what happened at The Hague. What this ruling or determination by the ASP was all about, specifically on the Kenyan delegation's, concern on Rule 68.
Let me move very fast and start from the point of, from ground zero, so that for the public to understand what we are talking about. One, there was a post-election violence in 2007. Then the civil society plus the international community investigated this matter. This matter was supposed to be handled by the Kenyan courts. The Kenyans failed to handle this matter here. We referred this matter to the ICC. The ICC started their cases in 2012. When the ICC started their cases in 2012, the law that was there was that they could not use evidence that they could not use rules and procedures that were not there. They were only to use the rules and procedures that were in place. And one of the rules and procedures that was in place pursuant to Article 51 was that the evidence must be produced And that evidence and the rules that were there cannot apply retroactively. When we talk about retroactively, we mean that the rules cannot apply backwards. So that if a rule was not there yesterday, a rule was not there yesterday, if we pass that rule today, that rule cannot apply for an incident that happened yesterday. So that if the Pope coming to Kenya was not a criminal act, and the Pope was here, and Parliament today passes a law saying popes should not come here, then we should not go arresting Pope Francis because he came here. At the time he came here, it was illegal. So that was the position that was
Why
there.
Pope? But let's move on.
I've given it
a more proximal example.
Yes,
Thank you.
I've given the people to understand that the law, according to what is legal today,
Yes.
cannot be declared an illegality tomorrow when you go back to arrest those people.
Yes.
That is the position. So what happened, the evidence that was produced before the case of Kenyatta collapsed. The case came up for Ruto, and Ruto, the prosecution realized they will not succeed to nail Ruto. In 2013, a body created by the Rome Statute called the Assembly of State Parties the prosecutor and the judges petitioned that parliament, let me call it the parliament of the ICC, that we will not succeed in jailing these people because the witnesses have died, the witnesses have been coerced, the witnesses have failed to come. Amend the law. The ICC, the Assembly of State Parties, in November 2013, amended the rules of procedure and said that any evidence of somebody who has failed to come to court, who has died, who has been threatened not to come to court, will be admitted. In those discussions, there was a gentleman's agreement that those rules cannot apply to the ongoing cases. So those ongoing cases, that is where we talk about retroactivity of a law. That the law cannot apply backwards. So that was the gentleman's agreement. When Bensouda appeared before the judges...
That was the?
That is now 2014.
No, you've said that was the
That was
the gentleman's
That
agreement.
was a gentleman's agreement.
Thank you. Emphasis on gentleman's.
It is a gentleman's agreement. In international diplomacy, the principle of utmost good faith is the hallmark of diplomacy. So that what has been agreed in a diplomatic circle, you cannot really go back. The same principles as in the industry called insurance. Two industries that rely on commitment to what you've undertaken. Three, in 2014, 2015, Bensouda now applies to the court for that rule to apply on William Ruto's case and Joshua Arap Sang. And the Kenyan government and the defense of Ruto raises an issue that really there was an agreement, whether it is a gentleman's agreement, because the diplomatic circles is not a legal agreement, it is a gentleman's agreement. There was an agreement that these laws should not apply for these cases. The courts allowed the rules to apply. So the Ruto's case, lawyers file an application for an appeal in the appeal chambers. It is pending ruling determination. So now the Kenyans started a political maneuver by holding prayer rallies in this country, by also moving to the same Assembly of State Parties. Assembly of State Parties is a creature under Article 112 of the Rome Statute. That article provides for the Assembly of State Parties to look at the conduct, the oversight of the judges and the oversight of the prosecutor. So Kenya moves to that Assembly of State Parties with two prayers. One, a confirmation and a reaffirmation that the rules that were amended in 2013 will not apply to the Ruto case.
Of the gentleman's agreement.
Of the gentleman's position. Two, that the prosecutor needs to be investigated on the claim that they procured witnesses by paying them. There was a position held by the Western nations that that rule must apply in the Ruto Sang case. There was also a position that the prosecutor cannot be investigated. So the battlefront was one between the usage of that law and the non-usage of that law. That is the historical perspective. So what came out of the Assembly of State Parties? One, the Assembly of State Parties, with a lot of pressure from the Kenyan government delegation. That was the executive headed by Ambassador Amina and Rachel Omamo, plus the parliamentarians and the activists, and the civil society, which was on the other side. So the Kenyan delegation's position was upheld that one, that rule cannot apply retroactively. That was agreed. Two, they took notice that there needs to have an oversight mechanism to be set without actually giving that the 5 people Kenyans were pushing for got it. They only noted that there needs to be an oversight mechanism put in place. The civil society's position, out of this decision now, we have 2 versions. One, the government position is that Kenya won. The civil society's position is that they did not win. What the Kenyan government did not win?
Yes.
So those are two situations. I want to expound on it, what it means. For Kenyan government position, the fact that there was an affirmation that those rules will not apply, the appeal chamber will have to take what we call judicial notice that that rule will not apply. And once that is the position, then the appeal chamber will declare the usage of that rule not legal. And that is why everybody is celebrating that if the same parliament that passed that rule has confirmed that that rule cannot apply, then that Ruto's case will collapse.
Then it's one thing for Parliament to make a rule or a law.
Yes.
But we need to rely on a certain body to interpret law.
Yes.
Why is this done, Joseph? Because you cannot interpret law from a single point of view. You've got to relate with other pieces of legislation. Key among them now, the discussion we are having right now in this country is about Rule 69. But we'll be getting to Rule 69 in a short while. So, Simekha, you wanted to chip in on something.
Yeah, I just want to chip in. Well, actually, it's interesting you pick up that. That was going through my mind. And I like the analogy of using ASP, comparing ASP to Parliament. And indeed it's like that, Parliament makes decisions. There is a political body that makes rules or laws, if you like, but you must leave it to the judicial system to interpret.
So this was a political process at the
This
ASP.
was purely political.
International politics. Yes.
So, and this is why I said, and I still maintain my position, that it's not yet clear, because I tend to go with the position that this is a judicial matter that must be left to the judicial processes at the ICC. Then, secondly, what I really wanted to also come in and 2 things clarify that. One, you talk about civil society and international community investigating post-election violence. It's not a very accurate position. They played civil society and international. Perhaps I can speak authoritatively about civil society. Played a role in gathering evidence, in finding witnesses and so on. But the biggest investigator of post-election violence was the Kenya government, through the police and the intelligence services, up to and including part of the evidence at The Hague, being used at The Hague right now. It was not generated by civil society, but by instruments of the government of the Republic of Kenya, and rightly so, because they have mandate to do that, to carry out those kind of investigations. Civil society that has no mandate to carry out criminal investigations. So there, it's erroneous to imagine that civil society carried out investigations and that the evidence they produce would ever be relied upon. No, they don't have that mandate. And then, secondly, the role of the prosecutor and the judges at the ICC, their role is not to jail people. Their role is to dispense justice. The prosecutor presents a case and defends to the best of their ability based on the evidence they have. If they think they need to get a conviction, that's what they push for. The judges listen to what is being presented to them and must act and make decisions in the course of justice, in the best interest of justice. But their role is not there, in my opinion, necessarily to jail people that, you know, we have put you there to jail people. It is to, in my opinion, to dispense justice to those who need justice. And those who need justice are the accused, the people who have been wronged, and society in general. All those three parties need justice.
Those dimensions have to feature, have to feature and be taken care of. Omari, you're itching.
Yes.
You need to say something.
Justice. What is justice? Justice is balancing the rights of the accused, the rights of the victims, and the rights of the public interest. They are free rights. One, the rights of the victims. Will the victims get justice because an innocent person has been jailed? Never. The victims will only get justice if the right suspect is arraigned in court. If Ocampo failed to do proper investigations, to take the right person to the ICC, William Ruto and Sang cannot be sacrificed because they are victims. That must be very clear, that justice must not be attained by punishing people wrongfully. Number two, the rights of the accused. When you are saying that the rights of William Ruto and Sang are being infringed, what do we mean? I go to the American Constitution. The American Constitution talks of that you can, it is found in the American Constitution that you cannot apply the law retrospectively. But for William Ruto, yes. We go to the European Union Convention on the Treaties on the Criminal Law. There are 4 treaties. All of them say you cannot apply the law retrospectively. But to Ruto, it is okay. We come to the Kenyan Constitution. You cannot apply a law retrospectively. But to William Ruto, it is okay. So what we are saying, worldwide, universally, there is no country known existing in the whole world where that law can be applied retrospectively.
As it is, yes.
So is the right of William Ruto and Sang being compromised because they are Africans?
There is something you raised, Danstan, Omari.
Yes.
And I would like even, Joseph, you can weigh in on this.
Yes.
In terms of balancing the wheels,
yes,
or balancing the scales,
yes,
and looking at the rights of the accused,
yes,
rights of the victims,
yes,
and the rights or what is perceived to be public interest. In this particular case, what is public interest?
I was coming there. The public interest is the victims must get justice.
What is public interest, Joseph Simekha?
Yeah, it's a combination. It's a combination of things. That first of all, that someone must take responsibility for what happened in Kenya, because it is widely perceived. I would even hazard a guess that it's factual that quite a bit of it was planned, and someone has to take responsibility. That is in defense of public interest. There are people who died, people who lost, and so on. They need to feel that there has been some kind of taking of criminal responsibility. Well, even political, social, and so on, where we have failed. But at the very minimum, that someone has taken criminal responsibility.
The right person has to take criminal. Yes.
The right person has to be the one to take responsibility. Right now, well, then the other side, already before Mari came in, I'd mentioned those 3. I talked about the accused, I talked about the victims, and I talked about society. What is in the interest of society for us in Kenya is that there should never, ever again be a repeat of what happened here. That we must live in peace on the basis of truth and justice. Not on the basis of propaganda and political expediency and say that, you know, we are peaceful, we have created harmony between 2 communities and therefore Kenya is peaceful. No. Kenya needs to live in peace on the basis of 1, the truth, 2, justice. So if and when that court is able to help us to bring out those 2 things, fair enough. Are the 2 people, the 2 Kenyans, they are the right people? I do not know. I cannot even claim to know that they are the right people or the wrong people. I just know that they are before a competent judicial tribunal, and we wait for the tribunal to pronounce itself, the court rather, to pronounce itself on them, then we shall know. I am sure they have the right of appeal should anything go against their favor. So for me, it's just to stick on the issue of principle. I refuse to attack ICC on the basis of the fact that these are two Kenyans, these are Africans, and so on.
Yes.
I completely refuse, but I want that we create and support national and international institutions in the interest of truth and justice.
Which we ratified ourselves.
Yes.
And we later said, let's not be vague.
Yes.
We go to the Hague.
Yes.
But we expected justice.
Yes.
All right? We expected justice, and we are not by any chance saying that there is no justice at the ICC. We are simply saying that the process needs to be subjected to the kind of conversation that we are having right now on Iron Politics.
One quick thing, please, kindly, I'm sorry, but just one quick thing. Just one quick thing.
And he is sorry.
Because I know that I really just interrupted you.
Yes.
Again, I would not like us to lose sight of the fact that there are exceptions internationally. When certain special things happen, and they have hurt humanity so much, we have presidents. We can create a law and a procedure and apply to those things retroactively. In the
genocide.
In the interest of humanity, yes.
The genocide in
it's
Rwanda
not as if it is
being an example.
Yes, it's not as if it's cast in stone that it can never ever happen. It depends on the gravity
of the situation.
what we are trying to punish.
Let's look at interpretation of this particular decision by the ASP.
Yes.
Should this go the way the Deputy President expects, that they will find that indeed they can't apply, and therefore come January 14th,
yes,
the no case to answer motion, when the case will be listened to, that the judges will come to a favorable conclusion, what will happen then? And on the flip side, if interpretation by the court finds that indeed what was admitted before the court will sustain this case to its logical conclusion, what is expected to happen?
There are two scenarios. One, the judges might be obstinate and pursue a policy that they need to survive. And the only way to survive is to bring the head of William Ruto and say he has a case to answer. They will have justified the financial people who fund that court, ignoring all the irregularities of the law. Remember, the judge's decisions are discretional. Once a judge says you are guilty, the only position is you are guilty until you go to an appeal court. So they might pull a fast one and say, William and Sam, you have a case to answer. Go to the dock. That could be one direction. Two, the judges might find that there is no case to answer. If they agree that there is no case to answer, William Ruto's case collapses and he comes back home as an ordinary citizen. He will not, the case will have died in totality. So those are the scenarios that we are waiting for from the judges. Two, remember that is in the lower chambers. There is an appeal in the appeal chamber that is challenging the validity of the acceptance of recorded evidence. If that comes early and says, but the lower chamber had no locus, had no basis on law to accept evidence of recorded evidence, then the lower court will only be faced with only the evidence of the people who testified. Remember very well, Bensouda has the office of the prosecutor said they do not have enough evidence to sustain a case if they do not rely on recanted evidence. So if the higher chamber confirms that, when the lower court collapses. Those are three scenarios that we are anticipating. On now the issue that will be there, and as I've said, and this is what my position is, the ASP was a political process. But in the ASP, the judges and the office of the prosecutor are part of that political process. In 2013, the judge who was representing the court was inside, and her presentations were taken into. That is why she recanted from hearing the appeal because people are saying you are part of the proceedings. In this ASP, Bensouda's office was part of it. The judges were part of it. So that's why it becomes very tricky. How do you say there is the independency of the judicial process? There is nowhere when Parliament in Kenya here is making laws, members of the judiciary sit inside.
And are consulted.
Because
never. The balancing act too is very tricky.
It is very tricky.
But then again, before we wind up this, because we've got around 5 minutes to the top of the hour, Rule 69.
Yes.
Does it present a threat to the application of Rule 68?
Let Omari start.
On that one.
Yes.
Then
Let Omari start on that one.
Yes.
Rule 69, and in my position as a lawyer, Rule 69 as it is
right now
allowed for usage of recanted evidence. Even before Rule 68 was amended. In the wisdom of the people who went for Rule 68, they left Rule 69 intact. The only challenge that is there is that in Rule 68, Bensouda went pursuant to Rule 68. In law, the provisions of the sections of the law that you go with are the sections that the court will rely on. The court cannot go enforcing or using Rule 69, which was a mistake on the Bensouda's argument. Had she gone with the two provisions of Rule 69 and Rule 68, Ruto could not have survived. Instead, they narrowed to Rule 68. They amended Rule 68. So, in essence, the Rome Statute had contemplated the usage of recanted evidence from 2000 and...
But Rule 69 is still intact.
That's what I'm saying.
As it is.
Because of Rule 69, so that was from 2002. If you read properly, Rule 69 allows for usage of recanted evidence.
So shall we be back to the ASP to amend Rule 69?
Depending on whether
Joseph.
What I'm saying,
depending on whether it threatens anybody's interest, any significant person's interest or not. Anyway, first of all, I admit you caught me off guard there when yes, so I make a confession, you caught me off guard. I was thinking that you'd move to something else.
Yes.
But anyhow, I think at the bottom line, 68, 69, 70, 20 is what I would really be interested in is the veracity of this evidence. That if this is factual, objective evidence, then parties at the court should not be afraid of it. This is why I really like the emphasis of our Constitution and our Chief Justice, not everybody at the judiciary believes in this, on substance rather than form, procedures. That yes, we do have procedures, but please do not just kill a case on the basis of procedure, that substance should always take precedence. That I wish that all over the world, when we are looking at such things, in judicial processes, that we must look at substance, because it happens in our country a lot before pronouncement of the new constitution and the emphasis of the Chief Justice, that on a mere technicality, we can knock out a case even before coming to the merits of the case. So here again, we are saying we can knock out evidence even before we look at the merit of that evidence. Whichever rule we use, I would just wish that the judges are given an opportunity to look at this evidence and, based on their competence as judges, determine the veracity of this on the basis of merit. But I'm not losing sight of the fact that evidence, it's only fair that it gets tested. But when we look at the special circumstances under which this evidence was recanted, then you'd say, let's make an exception and ensure that this is before the judges so that they can they can look at this, evaluate this evidence themselves on the basis of the merit of the evidence.
Then my final thing.
Yes.
Final.
Final, actually.
Yes.
I feel very sad when we polarize issues in this country and treat civil society as if it's not part of the country, as if it's anti-Kenya. And I've seen politicians like Duale actually say the Europeans are using civil society to undermine a sovereign country. The people you call civil society are Kenyans with Kenyan interests.
And they are sovereign.
And they are sovereign also.
Sovereign
they are part of the sovereign will of this country.
Yeah.
They receive foreign support exactly the same way the government of Kenya receives foreign support. At least they don't receive military support like the government.
Let's move on.
Yeah, so it's important to appreciate that we have different facets of society. And all these have a role to play in building our society.
Yes.
We don't always have to agree on everything. It is through these kinds of intercourse, intellectual intercourse,
yes,
that society develops to the next level. When we have these healthy conflicts between the different facets of society, that society develops to the next level. So we must stop this thing of saying that civil society is something being used by Europeans to undermine. It's a very crude way of reasoning. It's beneath, it should really be beneath us. Let us reason and argue on the basis of merits of our arguments.
We hear you.
Yeah. Let me finish.
Omari?
I had the right of only 1 second. 1 second.
Okay, all right, fine.
One issue. He's talked about the Chief Justice saying, let the matters be heard on merit. In the Raila Odinga versus Uhuru petition, the same Chief Justice knocked out the affidavits of Raila because the procedure said within 8 days. So let us not have double standards. Number two, on the question of the civil society,
yes,
are they serving the interest of Kenyans? Not at all. They are serving...
We cannot conclude that they are not serving the interest of Kenyans on this set. But we can say that, as Joseph is saying, that across the board, let us all respect the role of each other in the process.
Yes.
And respecting the role of each other in the process entails having that sovereignty in you.
Yes. Nobody should be citizenship.
Nobody should be compromised in the process. And even the process must look legit as it is. I'm being told really.
Yes.
Really.
Really.
No more.
Let us
and I hear you. We wind up Eye on Politics today. Thank you so much, Danstan Omari. Thank you so much, Joseph Simekha, for your contribution on Eye on Politics today. Of course, this conversation continues. Come Monday latest, we shall have another edition of Eye on Politics. And of course, we shall bring you political understanding in a way that you can grasp, all right? So we wind up for this day. God bless you all. Enjoy what is left of your Monday. We catch up tomorrow. Same place, same time. I'm Samuel Njoroge.